at least in this particular case that I'm thinking of, the corporate trustee was not, um, was not in existence anymore. You couldn't find them, but there was still the requirement in this now irrevocable trust that a corporate trustee had to be appointed. So we had to do some changes to this trust through a non-judicial settlement agreement, and as a result, it was a pretty large legal fee that I'm sure that the folks that set it up originally did not intend to happen. So just a ton of stuff that can go wrong with these AB trusts because they make what could be a simple solution into a very complex problem.
Yeah, and that's another area where you may see this arise is at the passing of one of the spouses where this type of plan is in place. Now, given that the tax federal estate tax exemption amount is so much higher than it used to be, which was sort of what gave rise to all of these planning tools, then the surviving spouse is left with an interpretation of, well, do I need to fund this trust? Do I need to fund the family trust? Do I need to fund the credit shelter? Do I, all these different questions that come to bear at that time. And then it becomes, does the trust language support maybe not doing that, or is that a requirement? And so, are you in keeping with the terms of the trust and following that and not breaching that fiduciary obligation to serve as the trustee and carry out the terms of that document? And so, just very careful analysis needs to be done on each of these kind of trusts to ensure that each of the protections that are there are still actually protecting what the testator had made as their intent versus the present realities and need for access to those funds. And so that can be a very big challenge for folks to navigate. And again, it's a stressful time when that loved one has passed on. And so it is helpful. I think the federal rules changes in recent years anyway have been helpful to allow like a portability election, for example, which can provide some more options for the family at taking a look at that passing and determining, well, can I just take whatever my deceased spouse unused exemption amount is and port that over and still accomplish the same thing, but then have access to those funds?
Yeah, and that exclusion amount, applicable exclusion amount that determines how much estate tax an estate has to pay, it really has changed dramatically over the years. Right now, it's almost $14 million
Mhm.
per married individual or per individual, and if you're married, you get to double that essentially. And anything $28 million and under isn't subject to the estate tax as long as you choose portability, using that uh, applicable exclusion amount from uh, your deceased spouse. So uh, $14 million, that there aren't very many estates that we come across that are that high. Um, but then it was at one time, I'm thinking it was in the early 2000s, that that applicable exclusion amount was as low as $1 million, and that's definitely a more common, uh, you know, level of net worth that we see from time to time in our practices. And so, yeah, was there a widespread need for this type of planning? You could make the argument that yes, there was, because of how low the exclusion amount was at any given time, but um, not so much right now. And because it isn't, it doesn't have to be as complex as it used to be. Having a simpler type revocable trust might be a better option if all that we're trying to do is everything to the spouse first, and then from the spouse to the kids. If that's what we're trying to do, then a simpler solution is definitely available.
Yeah, and keep in mind as well, we're talking about Indiana law. And so Indiana had an inheritance tax at a point in the not so distant future or past.
Yeah.
Hopefully, it doesn't
Yeah.
again in the not so distant future. But there was some planning that could be done there to help maximize the use of any spousal exemptions when that first spouse would pass. And so that was a big part of this planning tool as well that is not really a concern for Indiana residents right now because there is no Indiana inheritance tax. And so as you're thinking about this, every state has different and unique rules as to how it handles this. And so there is just a wider spread. Uh, just it seems like just in general terms, the law is being more aware of, hey, let's make it easier to transition assets at the passing of someone and not putting so many, red tape requirements in the place so that at a time again of grief and things, we're not dealing with little things that it shouldn't be dealt with. So you see transfer on death deeds coming to Indiana for real estate, which is a very popular tool to help transition an asset. Now there's a whole host of considerations that you would want to think about with that, but in general terms, if, like you say, we can utilize sort of a joint spousal trust and detail how we want things to occur to do probate avoidance, that's a great tool that's available. And there's some tax planning built into that as well, typically in how I set those up, that if for some reason the rules change on us, we can utilize these tools and techniques. We just don't have to. We haven't made it mandatory on everybody unless the situation warrants it.
Yeah. Yeah. I definitely think you just have to consider what is the best solution for your situation. It might be that, in a blended family situation, we do want this type of split between, 50% goes to the survivor's trust and the surviving spouse has the ability to do whatever he or she wants to do with it. And then 50% goes to this family trust where kids have a vested interest in it, and that secures a portion of the funds going into to them and not really subject to the surviving spouse and really the surviving spouse's future spouse. That's a big reason why you still might want to do that kind of planning. But, you know, like I said before in this podcast, a lot of people weren't even considering, a blended family situation. It's just, a married couple that had been married for 20 years, they had some kids together, they still got an AB trust. And to the extent that those trusts are still out there, they're probably a little bit too complex for the family situation, I would say.
Yeah.
Yeah, in my experience, using the non-judicial settlement statute under the Indiana Probate Code is a great tool that attorneys have. We really haven't talked much about the non-judicial settlement agreement, possibilities, if you will, Seth. But that is one way that you can solve problems that arise within a trust if there's some arguable point, and the statute kind of spells out who what issues can be decided by a non-judicial settlement agreement. But if you can come to an agreement on who the trustee is supposed to be, if there's a trustee vacancy, or what kind of administrative expenses are reasonable, or there's just a whole list of items that can be considered through a non-judicial settlement agreement that can kind of solve problems without having to go to court. That's why it's called a non-judicial settlement agreement. You could go to court and get a judge to do the same thing, but if you already agree, then you don't have to, and you can go ahead and get it done that way. So I think that's one option that attorneys, you certainly don't want to do it pro se, without an attorney, but having a non-judicial settlement agreement is one way of solving trust administration problems.
Yeah, and it's a great tool because it typically the individuals involved sort of know what the intent or what was supposed to have happened was, and there's no dispute over that. where that would break down is if one of the beneficiaries has a different opinion than another of the beneficiaries, and we can't then by definition get an agreement. And so that's the time that you would maybe petition to docket the trust or ask for instructions on behalf of the trustee as to what does the trust really say or permit in this scenario, or here's the proposal, can we do this, and the court could hear evidence on that and determine what the trust terms actually say, which is another vehicle if the trust itself isn't exactly clear, or there's a dispute from the beneficiary standpoint of what does this actually mean, and the court can step in those situations as well. But that non-judicial settlement agreement is a great tool in the sense where everybody kind of says this is what we understood to happen, we're all okay with it, even though the trust may not actually say this. There was a reason for that. You mentioned, the corporate trustee requirement, but that particular trust company no longer exists. Well, we're okay with a professional fiduciary standing in, or this bank, or something else, and you can get the trust restarted and reconfigured to ultimately carry out what it was supposed to do in the first place.
Yeah. So and that's where a lot of our practice comes in, is like the trust is great, and it can, as long as it works well, it can be really smooth. But even attorneys that put trusts and wills together, we can't necessarily see the future. We like to say we can see the future, but we can't. And so having these tools to be able to tweak estate plans, that's kind of nice that we have that ability to kind of help a family through a problem that they're having that was unanticipated when the trust was originally put together.
Yeah, and everybody's position changes with time and circumstance. And so I always tell clients we plan for what we know and we can reasonably foresee. We can't foretell, 10 years down the road what's going to happen. This is why we try to review these plans on a somewhat regular routine to account for changes that may have happened either from a factual scenario in the family's life or from a legal perspective in terms of the laws and the rules that apply to the trust. There may be some changes there. And so most of the time, those changes aren't saying, well, this is now not going to work. It's just well, if it was written before this date, it's okay, but after this date, but there may be newer techniques or tools available, again, to simplify the process as much as possible, to have as least administrative burden on your loved ones at the appointed time, and allow things to happen the way you intended them to happen.
For sure. Well, I think that is a good discussion today about how trusts have evolved, especially AB trusts have evolved over the last 20 or 30 years. There are certain trusts that are set up in a way that make it more complex than it needs to be. And, today's modern trusts are maybe a little bit simplified compared to what other trusts looked like so long ago. And then if there is a trust that has been executed and you can't revoke it right now, it's good to know that there are ways of dealing with that trust administration if problems arise. And so just kind of put that in your toolbox and understand that there are ways of dealing with trust administration problems, even when we can't go back in time and get rid of the trust, even though we might want to.
Yeah, and that's a great point is, as long as there's typically options. Obviously, if it's irrevocable, there's going to be fewer things that can be done with that. And we talked in the past about sort of the moving box analogy. Once you've sealed up that moving box and taped it shut in that irrevocable nature, the trustee just has the option to follow everything that's in it. But if there's any kind of flexibility, we want to utilize these tools at the appointed time to help carry out the intent of what the trust was really meant to accomplish.
Yep, for sure. Well, thank you as always, Seth. I think this will do it for another episode of the Lifetime Legacy Lawyer podcast. what is the best way for people to get in touch with you?
Thomas, as we've moved into the new year, we have a new website domain. Our
Cool.
existing one works, but it's adlerattorneys, plural.com. So adlerattorneys.com. That will direct you to our contact us page and obviously matches the name of the law firm as well. So visit that and reach out if we can be of assistance. How about you?
Well, that's wonderful. I didn't know that you were going to a new domain, so very exciting. AdlerAttorneys.com. Uh, Best way to get in touch with me is viclaw.org. Viclaw.org. You can book a call there. And also, you can check out my masterclass on Medicaid planning. That's also an option there on the website. That you can find that under the resources tab on viclaw.org. I think that will do it for today, Seth. We'll see everybody next time.
Thanks, Thomas.